Hi everyone, my name is Ramana Reddy. I am a tax lawyer from Hyderabad. Today I wanted to talk to you about provisional attachment under the GST regime. It is considered one of the most draconian provisions under the GST Act, and it has become quite fashionable for the department to invoke this power. So, the subject matter of this video is going to be what is provisional attachment, why is it done, what is the procedure, and what are some of the arguments that you can raise if that ever does happen. So, what is provisional attachment? So, provisional attachment basically means that there is an investigation that is pending against you, and there is, or at least the department feels that there is a likelihood that they may not be able to collect on that money because, for whatever reason, because they think you're going to run away, they think that you're going to sell your assets before the demand is put forth by the department, for whatever reason, but they feel that they will not be able to collect the money from you if there is liability. So therefore, what they do is they provisionally attach your property, and this has become quite fashionable to do so by the department. So, so that is the background. That is the purpose as to why provisional attachment is done. It is done to protect government revenue so that you don't shut shop or you don't just escape or you don't disappear. Now it has now so section 83 of the CGST Act talks about provisional attachment, and to provisionally attach your property they have to be in some proceedings that are launched against you, and it cannot be any proceedings. Section 83 provides for a list of about 5 to 6 types of proceedings that are instituted against you, and only when these kinds of proceedings are pending would the department have the power to attach your property provisionally. So one of the first things that you should do, that if your property is ever attached, the first check is is are any of these proceedings that are mentioned under section 83, are any of these proceedings opened or started against you? And if none of those proceedings are initiated against you, then that provisional attachment, you can challenge that in court or through a writ petition, or you can file an appeal and try to get that closed. Now, well, I have my notes here, so I'm going to try to see what we can do here. Now, the other thing to note is that a provisional attachment against you can only be done within 1 year from the date of passing the order. So, say for example, the commissioner issues an order provisionally attaching your property on the 1st of January. Now, the commissioner can only do so for a period of 1 year. So only until December 31st of that particular year. For anything beyond that, he will not be able to continue provisional attachment, and therefore, if your property or is provisionally attached for more than 1 year, that's one ground that you can take, saying, look, 1 year has expired, and therefore my property should not be provisionally attached anymore. Now, this is just basically a basic overview of what provisional attachment is. Now, what is the procedure to be followed if your property is to be provisionally attached? So, unlike other proceedings where a show cause notice is first issued to you, in this case there is no prior show cause notice that is issued to you. So it is not like the commissioner will say, hey, look, I am going to provisionally attach your property. Do you have any objections? And understandably, the reason could be for not providing show cause notice could be that if I provide the show cause notice to you, you may just disappear. So, and the whole purpose of provisional attachment is to make sure that you don't disappear or that you don't sell away your assets when an investigation is pending. So, what the law contemplates is that you have uh, that there is an order that is passed against you, and the commissioner after the commissioner passes the order, you have a period of 7 days. So you have 7 days to argue as to why your property is not liable to be attached. And uh, from January 1st he attaches till January 7th, you have the right to file objections as to why your property should not be attached and why he should release your property. Now, do your best to file it within 7 days. I mean, there are court decisions that have said that if you miss the bus or if you don't file it within 7 days, then what happens? Can the commissioner say, oh, look, you filed it on the eighth day or the ninth day, and therefore I'm not going to consider your objections? Well, some courts have said that that is not the case, that you still have, that you can extend that time but make sure that you file these objections as soon as possible, preferably within the 7 day period. So that is basically the procedure. He attaches your property, and then you have a period of 7 days to file your objections. Now, what one of the unfortunate things about provisional attachment under GST is that that similar provisions also existed under the Central Excise Act and the Service Tax Act and so on. But one of the big distinguishing features was that in the old regime, you had, or the department had issued circulars, or the provision itself made sure that when such drastic powers are exercised, then that these provisions provided for offense, or providing guidelines to officers as to when you can and when you cannot attach these, the property of taxpayers. An especially draconian way to do this would be to attach the bank account of a business, because the at least the thinking potentially could be, okay, I am going to conduct a raid on this business, so let me also attach their bank account, because if I do that, then I'm going to put more pressure on them, I'm going to squeeze them more, and therefore, they're going to come up with some kind of payment, or they're going to come up with I don't know, with some kind of admission on their behalf. So when these kinds of powers are provided for, at least under the old acts, there used to be circulars that said, look, you cannot exercise these powers unless there are 1, 2, 3, 4, 5 criterias, or you can only exercise these powers in these circumstances. These circulars and so on are missing under the GST regime, and that is something that is worrisome. Now, assuming that your property has been attached, or let's say worst case, your bank account has been attached. Now, what do you do? What are some of the arguments you can raise? Now, these are just some of my ideas. This is not legal advice. Definitely talk to a lawyer before you reply to the commissioner's order attaching your bank account, or filing anything in court, or filing an appeal. But these are some of the considerations that you must keep in mind, or some arguments that you can raise before the authority if there is a provisional attachment against you. So here are some of the things to look at. The first thing to consider is the Act provides, or it empowers the commissioner to provisionally attach your account. Now, if the commissioner provisionally attaches your account, that's okay. I mean, at least on this account, at least on this ground, and you can move on to other grounds. But if an officer other than the commissioner, signs the order and he says, and he provisionally attaches your account, then one thing to look at is, has the commissioner properly delegated the power to the other officer? Because under tax law, these laws are strictly interpreted. So the commissioner cannot loosely say, hey, my assistant, why don't you go out and provisionally attach, X's account or Y's account. So there are methods of delegation that are provided under the GST regime. And if your account is ever, or if your bank account is ever provisionally attached, or any of your other properties provisionally attached, always check who is the authority that has signed the order or who has given the order, and see if that delegation has properly taken place. So that's the first one. Now, moving on, the other requirement of Section 83 is that the commissioner should be of the opinion that the provisional attachment is necessary to protect the interest of government revenue. Now, he does not need to state what is the reason in his mind that he feels that, that he will not be able to collect. But if you ever challenge that reason. So let's say in the 7-day period, you file your objections and you say, hey, commissioner, look, why don't you tell me what is the reason? Like, why do you feel that I am going to run away? Because look, I am an upstanding business. I have been paying my GST, my taxes on time. I have been operating my business for the last, how many ever years. So therefore, tell me. I mean, I am questioning you. I am challenging your reason, or at least I'm challenging your decision to provisionally challenge or to provisionally attach my account. So while there is no requirement for the commissioner in the order to say as to why he feels that a provisional attachment is required, if you ever challenge that reason, then the commissioner should at least indicate some grounds as to why he is or why he feels that your bank account or your property has to be attached. And the other reason or the other thing to look at is, the reason cannot be, look, I think you're evading tax, and therefore I want to raid your premises, and therefore I'm attaching or provisionally attaching your bank account. That cannot be the case, because you will say, look, okay, those are reasons for you to come and conduct a raid on my premises. Those reasons are fine. But you need to provide a set of separate reasons as to why you feel that I am going to run away, or why you feel that there is a provisional attachment that is necessary in this case. So, in other words, the commissioner has to make out a separate case as to why a provisional attachment is necessary in this case. And if your bank account is attached, and this is an extremely drastic power, because what this does is it literally cuts out the blood supply of the business. I mean, if as a business my bank account is attached, I cannot pay salaries, I cannot, pay my vendors, I cannot pay any other duties that I have to pay under law. So literally, you freeze my business. So if your bank account is attached, you are entitled to question the department, why are you attaching my bank account? Why are you not attaching, say, for example, my plant? Why are you not attaching my machinery? Why are you not attaching my other assets? Why are you attaching my bank account? Because if you attach my bank account, that literally kills me. I mean, it's one thing for the department to come and collect whatever money and to protect their interest. But it is another thing to kill the golden goose that that lays all these eggs. I mean, if you kill me as a business, then there is no way that you are ever going to collect any amount, any money ever in the future. So if they ever attach your bank account, one objection that you can raise is, well, why don't you attach my, or all these other assets? Why are you coming after my bank account? So that's another thing that you can do. Now, if that is not happening, another thing that you could say is, let's say, for example, there is a liability, or you or the department says that we suspect that you have evaded tax of 10 rupees, and you have input tax credit in your account. You have input tax credit, say, of 100 rupees. So what you could do is you could tell the department, look, you want to protect the interest of government revenue. So what I will do is I will block, or I will, or why don't you attach 10 rupees of the 100 rupees of the input tax credit that I have in my account. And once you attach, that 10 rupees, I will, so don't freeze my bank accounts, don't freeze the remaining 90 rupees of input tax credit that I have, only freeze, say, the 10 rupees of ITC, just to protect this, or, just to protect the interest of government revenue. Or you could say, and this is unlikely that this would fly, but you could say, look, I will state under oath that my bank account has, say, 100 rupees. I will state under oath that I will maintain a minimum balance of 10 rupees at all times till the investigation is complete, or till an assessment order is given against me, so that the department is assured that I have 10 rupees still in my bank account. And obviously, as I said earlier, if that period exceeds 1 year, so if the period of provisional attachment exceeds 1 year, then make sure that you raise the ground that it has exceeded 1 year, and therefore uh, the department cannot continue to provisionally attach. Now, another interesting ground that you could possibly raise is, so let's say there is a provisional attachment of 10 rupees, and then the the matter runs its course. Then the department issues a show cause notice. You file your objection. So let's say the department issues a show cause notice of 10 rupees. You file your objection saying I'm not liable to pay any tax at all. Then, but the government, or the department, rejects your argument and levies a tax of 10 rupees. Now, at this stage, let's say your property is still attached. Now, at this stage, you have the right to file an appeal. If you file an appeal, then one of the conditions to file an appeal under the GST Act is that you need to deposit 10% of disputed tax before the appeal can be numbered or it can be heard. So going with the 10 rupee example, you would have to deposit 1 rupee in the, before filing the appeal, so that the appeal will be heard. Now, one of the provisions under the GST Act says that if you file an appeal, then, and you pay 1 rupee as the tax amount, then the balance 9 rupees is stayed. So what that basically means is the department cannot recover the balance 9 rupees. Now, let's say you file the appeal and the provisional attachment is still in vogue. So what do you do then? So one argument that you could potentially raise is, look, I have filed an appeal and I have paid 1 rupee as the pre-deposit, and the Act provides that the balance 9 rupees has to be stayed. So how can you say on the one hand that the balance 9 rupees is stayed, and on the other hand also continue provisional attachment? So this is just another thing that you could raise, and see how that works out. So, that is basically a brief overview of provisional attachment under Section 83 of the CGST Act. And, I hope this was helpful. If you have any questions, comments, love mail or hate mail, feel free to drop them in the comments. Although I may not respond to all of them, I definitely read all of them. So thank you for watching, and until next time.